Hello, everyone. Welcome to Arbitration Channel. My name is Lauro Parenti. Today, we are here to start a new project, the special product Client Perspective in Arbitration. I would like to thank you, the King Spalding and the Nivalium, to be the sponsors of this project. And today, our host, Erica Franzetti from King Spalding in Washington and Miami, and Cristina Ferraro for Miranda and Amaro Abogados, Lima, Peru. We're going to do the first interview. The idea of this project is listing the client and know who pays the bill. Erica, the floor is yours. Thank you very much.
Thank you very much, Lauro. It is a great pleasure to be here today with my friend Cristina Ferraro interviewing Marco Castilla, who is the Division General Counsel for Latin America at Qantas Services in Houston. And Cristina and I have the honor to represent Quanta in a couple of disputes and interact with Marco on regular basis because of this. So we know that in addition to being a wonderful person, Marco has extensive legal and business international experience, has an LLM from Harvard Law School, a management and finance certificate from Harvard Business School, and not only a JD in Mexico, but also an engineering degree in Mexico. And Marco, I know your professional experience is as diverse as your academic experience. I know that before going in-house, you were a partner at a U.S. law firm, and you worked with the United Nations at the beginning of your career. So I will have to start by asking you to share a little bit more details with us about your background. How do you think that your experience with public international law and then in private practice impacts your current position as an in-house counsel today?
Well, thank you so much, Erica, for the invitation, and also to Arbitration Channel for giving me the opportunity to share some of my experiences. Well, yes, as you mentioned, I have the opportunity to work in different forums. I started working in Mexico and in a private law firm at the beginning, and then I moved to, I had the opportunity to work for a UN organization called UNHCR, who is the United Nations High Commissioner for Refugees. I worked for that organization almost 4 years before going to the private sector. Of course, the working for international law, it's very different. That public international law is very different than private international law. You deal with issues that are affecting a broader or group large of individuals. No, of course, you deal a lot with multilateral institutions. You have the opportunity to be involved in a lot of things, particularly with compliance. So that was a very different experience when you are dealing with mass problems than going to the private sector. Now, when I decided to go to Harvard after I finished my LLM there and my business degree, I decided to try to go to the private sector, and I joined a couple of law firms, international ones, doing most was cross-border transactions. I've been focusing most of my practice dealing with Latin America, inbound investment from Latin America to the U.S. and also outbound investment from the U.S. to Latin American region. And then after several years of working in the private sector as a consultant, I decided to finally join a company as an in-house lawyer. The experience, the opportunity to have this experience in different forums and dealing with different people, of course, have helped me a lot in my particular job now, not only looking at legal issues, but also to have a more broader sense of the issues, trying to look at more at a 360 degrees view more than the going through the branches. So definitely has been helping me a lot in my career, having the opportunity to participate and experience in different type of forums.
Thank you, Marco. And now that you're talking more about your current role, could you tell us what does a regular day or what does your day-to-day involve?
Well, yes. Well, Quanta is a very diverse, very entrepreneurial company. Okay, they are very focused as very successful companies. They are always focusing operations, that are focusing growing the business. So of course, dealing in Latin America is always a challenge for that. No, it's very good. I'm a very big fan of doing work and projects in Latin America, but also that comes with several challenges. No, basically, my day to day is oversee all legal and compliance issues within the country that we have operations. We have operations, or we used to have operations in Mexico, Peru, Colombia, and Chile. Basically, I go and review the issues that are happening. Of course, try to communicate almost every day with my local colleagues down there, the legal representatives of there. I also try to be very proactive or ahead of the game, particularly responding to the senior management of the company. Basically, also, although we have a strong compliance department, also I oversee compliance issues that are happening within operations in Latin America. No? And of course, our long hours. In Latin America, we tend to work way past more than 5 o'clock. So normally are very long hours, dealing with different schedules and different time zones.
Marco, we know that arbitration is a big component of your day-to-day. Now, we also know you have experience with international litigation as well. So how do you compare the arbitration and the litigation proceedings that you've been involved in?
Well, a lot of different, there's a lot of difference between both. Of course, in litigation, you don't have the influence you don't have the opportunity to influence on the selection of the person who is going to help you to decide your case. You can see, or you know where are you going to submit your, or you are going to defend in which order. You can go to an appeal court, you can go to a district court, you can go to a county court, but you don't know who is going to be the person who will decide on your case. No. The court judge is assigned without the input of you on the parties. No, to the contrary, in arbitration you have the opportunity to select your arbitrator, at least one of them, and have a can choose of course the experience that this person will have or have. How familiar are with the subject matter of the case. And of course, you have the opportunity of ending and deciding what is part of the tribunal, because when you choose one of the arbitrators and the other party choose the other one, and basically both of them choose the third one, you indirectly have a say on who will decide or the formation of the tribunal. No? Also, in courts, you will face, a judge will be an expert on the law. Okay. They, of course, he will be expert on the procedure of the case, in how you apply the law. But in arbitration, you can choose, as I mentioned, an expert who can at least be more familiar with the subject matter that you are disputing. No. Also, it's very important to talk about speed. No, in arbitrations tend to be more because in the arbitration you can be involved in the decision of how the process will be done. You have more influence of the length of the arbitration. You can choose when are you going to submit your merits, when is going to happen the hearing. You have a lot of involvement in the procedural time. To the contrary, in court, you don't have that choice. No, you are facing, of course, some very strict and formal, procedures and timing, and of course, you are facing in courts these huge backlogs that not now most of the Latin American courts are facing after the COVID. No, so you don't know exactly how long will take your process, and that also implies in costs. No. Although normally you are more in control of the cost in arbitrations, because you are also in control of, or have some certain control in the process. And of course, in a court litigation, you don't have control of the time. So that could be a long process. Currently, for example, we have a litigation going on in Colombia, and of course, it's taking us now several years without seeing really the end of the case. No. Also, I think it's very important talking about the length of the process, the appeal decision. In an arbitration, normally you don't have the appeal. Most of the awards cannot be appealed except for certain circumstances. And of course, in litigation, either party may appeal the court decisions. No, I think there are other ones as well, like confidentiality, neutrality, but they are the main ones that I can comment.
And talking about different types of arbitration, we know you have experience both with commercial arbitration and investment state arbitration. So from your perspective, what is the difference between those two types of proceedings? And do you have any different expectations from the different proceedings?
Well, definitely are very different. No, first of all, commercial arbitrations, are the claims in a commercial arbitration is based basically in the contract. No, so the limited of the damages the damages are the claims for the damages are limited to the contract. And also in commercial arbitration, you can choose for different forums. You can choose for local forums, or you can choose for international forums. In investment arbitration, I think you are, of course, just limited to the only forum that it is, that is the World Bank Center for Disputes, and of course, you don't have to change. You don't have the possibility to change the seat. Also, it's not you cannot you can. It's more common to use commercial arbitration than the investment, because in investment arbitration you have a limitation also that you need to be part, or where you are, you have to be part, whatever the parties needs to be part of certain bilateral investment treaty that have this mechanism as dispute resolutions. You cannot just go ahead and claim an investment treaty without being part of one. No. Also, of course, the claims in investment treaties can be, of course, broader, because you can go beyond of what the contract says or the concession says. No, you can ask for damages related to your investment, although overall in the country or even in the region. Also I think also an important component is the appeal process, and the enforcement procedure as well. Sometimes in commercial arbitrations you have the issue with enforcement, and also the issue of facing some appeal against the awards. And I think it's easier to deal with that in investment treaty arbitrations. And of course, I think the costs are also important. In commercial arbitrations, that could be the local commercial arbitrations in the country where the project is seated, or international arbitrations tends to be, I think, less costly as just needed to engage 100% U.S. lawyers to handle most of the investment treaty arbitrations.
Marco, going back to something you mentioned about the treaties, right? The bilateral treaties not always being available to all parties. So in that, since the Arbitration Channel is a Brazilian platform originally, and as everybody knows, or everybody in this call at least knows, we don't have investment arbitration in Brazil, but we do have a lot, and I think it's increasing in number, commercial cases that have that are based on a contract but against a state entity. right? And I know that you do have experience with both investment arbitration and also commercial arbitration against the state entities. So how do you perceive any difference in the arbitration proceedings when you have a state entity as a counterparty, but you are in a commercial setting? Have you seen, for example, any resistance from the state entity in being bound by the arbitration clause or tribunal orders, or the awards themselves in your experience in several countries in Latin America?
Absolutely. Particularly when you are negotiating a concession or a contract involving a state-owned party, always they are tending to choose not for arbitration, but for the state courts, because I think they sometimes they feel more comfortable, of course, dealing with their own legal system. So first of all, there is always a push, negotiating these contracts on the arbitration clauses. Once you are able to, particularly in international cross-border, when now state entities or countries are more forced to accept arbitration clauses in order to get more investments, that's what you are facing. That, of course, there is a tendency to push on delaying the process of the arbitration. Our experience is that normally when you are trying to set up the process schedule for the arbitration, they're trying to push it as far as they can, try to delay the arbitration process. Also, of course, there is always the risk of having the enforcement of the awards. Once you get the award, then you will face with several challenges. No, if your arbitration case is seated in a country who is favorable to who is very influenced to the local courts or the local law, you will be facing a lot of challenge with enforcement of the award. Also, you are going to face the annulment challenges. So normally, it's going to be very difficult to when you are facing when you are facing a state-owned entity, particularly arbitration, and also, of course, in litigation.
Experience. Marco, you mentioned a bit about your experience with enforcement of awards. What has been your experience in the region with that, with enforcement?
As I mentioned, most of my cases, most of our cases has been against state-owned companies, although we have few with private entities. But it's not good only to have a good award. It's the possibility to enforce that award. And I think the good thing about having an international arbitration award is that you may be able to enforce it in different jurisdictions. Particularly if the losing party, where the assets are there, is part of the New York Convention or the Panama Convention. So it has been difficult, of course, because there is always a challenge particularly with local courts to enforce awards, and also sometimes take a lot of time, to doing that. So our experience has been, very challenging, Cristina. It's always, particularly in Latin America, it's always a challenge to not to comply with the awards, but just to continue fighting up to the end, no? And particularly when you don't have, in certain cases, the possibility of appeal. So the only way to kind of delay to comply with the compliance of the award is just through, the challenge of the enforcement procedures.
Marco, just a follow-up question on that question, because you mentioned that the treaty awards can be easier to enforce, and in our experience, actually, they are more likely to be even voluntarily paid by the states than commercial awards because of the financial, political, and social repercussions of these awards, and the fact that you could have potential removal of trade preferences or pressure from international organizations as the World Bank, the IMF, and so on and so forth. So do you have any experience with your awards being voluntarily paid, or you might not have an investment case that got to the end yet, I think, but I don't know. You're mute.
No. Excuse me?
Sorry, I thought you were mute. Go ahead.
Right. You mentioned one very important thing that I probably missed to mention it. That's normally when you are dealing with the investment treaties, you are dealing with the government. You are dealing with higher level of government that in commercial arbitrations involving the state, when you are dealing with particularly institution of the state. So most of the countries who allowed or have bilateral treaties, investment treaties that accepted this type of arbitrations, they put more attention on the compliance of these arbitrations. If you look at all overall the compliance of countries, state of institutions or countries, or involving commercial transactions or commercial arbitrations, you see that it's very low, the compliance rate immediately to the investment treaty arbitration. I think we are currently in one that we haven't seen the end, but based on the experience from other colleagues and what I have heard is, of course, normally when you go to an investment treaty arbitration, you have less resistance in complying with it because it's, of course, affecting your investment rates in your country. And you are dealing also with high-level officials within the government.
Yeah, that's definitely has been our experience. Now, changing subject here a little bit on confidentiality, which by the way may also be an important differentiator in commercial and disputes versus investment disputes, depending on the applicable rules. And there is a big push for more transparency in investment arbitration and frankly, to some extent, in commercial arbitration as well. So the question is, to you, how important is confidentiality during the proceedings and after the proceedings as well? We know that the ICC now publishes the awards unless a party objects. How do you feel, for example, about seeing your awards public?
I think the confidentiality during the process, I think, may allow the parties to resolve their disputes without the press, of competitors or somebody monitoring the situation. So I think I'm inclined to have this process to be confidential within the procedure of the arbitration. But I like I like really to have the possibility of these arbitrations to be, at least the awards to be published, and also the complete let's say report or decision of the award, because that will help others, other parties who are in similar situation, or to understand how certain issues have been resolved by other arbitrators, or in other particular cases. It's kind to have like a case law in the United States, or a jurisprudencia in Mexico, the opportunity and to the big opportunity to have the access of how other tribunals decided in particular cases, I think are very helpful for others who are dealing with the same issues. So I'm very inclined to have our arbitrations or our awards arbitrations to be published.
Marco, you mentioned Quanta has had activities in several countries in the region, and you mentioned Colombia, Chile, Peru. We were wondering if you've seen any difference in the arbitration practice within these different jurisdictions, and if you could comment a bit on that.
Yes, a lot. Having a similar legal system, traditions, does not translate into have a uniformity of laws in the countries. Although I think in Latin America they have been pushing to have a kind of a more uniformity in terms of how you deal with arbitrations within the region, I have seen several differences in different countries of how they treat or how they handle arbitration cases. No, for example, in Colombia and in Costa Rica, you cannot elect or select an arbitrator who is not a lawyer and who is not a citizen of Colombia, for example. No? You have, for example, deadline responses. There are different, for example, in the SECA in Panama, for example, we have 10 days to respond. In Chile with CAM or with the BCC in Colombia, you have 30 days to respond. In Mexico, for example, the time to respond is going to be set up by the tribunal. So you will see you see very different aspects of or different type of process or within the country in the region. For example, there are minimal requirements when you are requesting an arbitration, like the ICC in several countries. For example, you have almost in Lima or in Peru, you don't have to submit a lot of documents in order for request an arbitration, contrary to in Chile, or in Mexico, that you need to submit substantial amount of information in order to be able to request an arbitration. No, timing of course. Also, for example, we have an arbitration in Chile going on right now, another in Colombia. Timing for issuing the award is also another difference. For example, in Chile, they can take even 6 months, and in Colombia as well, in order to issue an award. Now, in Panama or Mexico, it's could be even shorter of 2 months. So definitely, Cristina, I can see that although they are working to have a more uniformity regulation in terms of arbitrations in the region, and more arbitrations institution has been grow. I think I see several difference having arbitrations in different countries within the region.
Yeah, that is the challenge and the beauty of arbitration, of international arbitration, because we have flexibility, but that means that we don't have a lot of harmony necessarily, right? I think that different institutions will have different rules, sometimes even in the same country. Now, how do you perceive, do you identify certain common issues in Latin America versus the US, particularly with respect to procedural issues, let's say production of evidence, discovery, for example, or anything else?
No, absolutely. I think a big difference between litigating in Latin America or having arbitrations in Latin America compared with the US, of course, is the production of documents. It's Latin America are not tend to have a huge discovery requirements, or being forced to have a big production and discovery of documents. Also, it's important that mention to, when you are working on the region, a lot of these procedurals or how you manage an arbitration in the country is also subject to local law. So each country should have different laws that are affecting arbitration. So you will also have the challenging of not having this uniformity or having a big difference with the US. Also, in Latin America, also a big challenge is it's particularly with local arbitrations, is that sometimes you cannot modify the procedural schedule. If you need it for certain reasons to stop, you have to suspend the arbitration. You cannot ask to the tribunal for the possibility of having an extension in the production of certain documents. You normally, what you have to do, it's really to request to suspend arbitration. normally what I see also is that and because of that reason, I think the process, the local arbitrations are more rigid than, of course, in the United States. Also, the way that, for example, you select your arbitrators in certain countries in Latin America are very different than the US. Now, in Latin America, sometimes arbitrators need to be decided by agreement of the parties. So you cannot choose your own arbitrator. You have to discuss with the other party, and both have to enter into an agreement of choosing the arbitrators. And if you can, it's going to be kind of a lottery, or done by the arbitration center or by a third party. So almost the parties have not the possibility to designate their own arbitrators. That's also an important factor dealing with local arbitrators and local arbitrations.
Marco, that's interesting. Now, in back to the document production, though, I do have a question that I'm curious to know about, which is, in your opinion, when do you think that document production should take place? Meaning, when do you think in general is more effective? And should it be broad or should it be narrow? What do you like best?
Well, it depends on the case, no? Depends on the case. If you are dealing with a very complex case, involving, a complex project or a complex dispute, I think definitely you will need to have a broader, discovery or a broader request of production, of documents. Also, if you are dealing with small cases or more simple cases, particularly when you are just dealing, for example, with a breach of contract, that the contract it's kind of it's not that complicated. You may need to go for a narrow set of document production, because, of course, every time that you have a narrow document production, is going to be it's going to be cheaper, and is going to be also less time consuming as well. It's going to take less time in order to produce the documents and also to review them. So it will depend on the case, Erika. I like to have the flexibility to have the opportunity to have a broader or a larger, set of production of documents, but it's going to be depends on the case. No, I try also to look at the efficiency of the arbitration, the length of the arbitration, also, of course, very important, the cost of the arbitration.
Marco, you've already started talking a little bit about strategy when mentioning doc production, and what do you think, or what has been your experience working with experts as a way to present your case? Do you usually work with them? And if you do, what is the role that you think they should play in the arbitration, and for the case? Which type of expert also do you usually work with?
Well, I think in my particular view, Cristina, I have always pushed to have experts in the litigations that we have in the arbitration or even litigation, because if you not normally in these cases, it's my word against your word. No, I did this, you did that, and it's very important, at least in most of the cases that I have been involved or the company has been involved, because it's construction projects, complex projects. Definitely, you need to have the view of an expert, experts who can assist the tribunal in its decision-making process by providing, the particular expertise on the case. So I think has been, in most of the cases that we have been dealing with, the role of the expert has been key in all our arbitration procedures. And, normally what you are looking, it's different categories of experts. Now, if you will need, of course, if you are dealing with a construction project, you will need to have a technical expert, an expert familiar with similar projects, an expert who is familiar with similar technical issues that are in dispute, and in other cases, you will need, of course, some legal experts, who are primarily used to explain, aspects of the relevant laws, in sometimes in which the tribunals are not familiar, no. And finally, of course, to have experts on damages. No, it's very important to have a third party opinion on the calculation of the damages that you're claiming. No, it's I think absolutely a big believer of the importance of experts, particularly in international arbitrations involving complex projects.
Marco, how about applicable law? How do you feel about applying the laws of the country where your project is, as opposed to the laws of a neutral jurisdiction or international law?
That's a very good question, Erika, since it's something that I've been struggling sometimes with that. Now, as I mentioned to you, I'm a big fan of doing businesses in Latin America. I always support or try to promote people investing in the region. And doing that is also to have some faith in the judicial systems and in the laws in this country. So I try to have some faith that things can be worked out in the judicial systems in those countries. But it also depends on the case. Depends on where the project it is, depends on the country. If the country have developed a good set of laws, and particularly also laws involving arbitration. So, also, if sometimes the country has some, the laws of that particular country doesn't favor, decision of international arbitration. So it depends on the case, depends on the size of the project. Depends if it's a cross-border transaction. Normally, when it's a cross-border project, you normally tend to have a neutral law, so to avoid the dispute. It's difficult to deal with that when you are dealing with, contracts where the state is involved or in concessions. You normally have a very minimal to say on which type of law is going to govern the contract, or at least govern the arbitration procedure. But when normally different entities from different jurisdictions or foreign entities are involved, I try to push for a neutral law. And one of the neutral law that normally you choose when you are dealing with Latin America, I normally try to tend to use New York law.
And one question on that, you just mentioned that usually in the type of contracts that you negotiate with state entities, especially, you have very little say on the applicable law. Does the same happen with the seat, the arbitral seat for the arbitration, or do you have more say in that discussion usually? And if you do, what do you tend to prefer as a seat, especially for the region, for Latin America?
Yes, well, that's also a very important question, Cristina. Very, very good question, because as on your choice of law, or particularly dealing with government contracts, you have also not a lot to say on the seat. They're always going to push to have the seat on their where the project is based, But I think definitely the seat on the arbitration is critical to maximize the efficacy of the arbitration, and also to avoid, to face these, sometimes new rules within these countries, or having the challenge of being able to enforce your awards where this arbitration is seated. I think that it's important. It's important to try to choose for a good seat. I know that we're talking here for Brazil. I know that Sao Paulo is one of the best places to have a seat there on arbitrations. And so I think definitely it's important. The confidentiality is also important. The enforcement procedure is important. So it's definitely a plus that you have to look at when you are negotiating arbitration clauses, the seat.
Marco, now let's talk a little bit again about arbitrators. You mentioned already the importance of selecting an arbitrator, and I know you get quite involved in selecting the arbitrators. So tell us what, in your view, are the main features that you were looking for when you were selecting an arbitrator?
Well, first of all, I think is experience on the subject matter of the case and the procedure. I think that definitely I will look for an arbitrator who have experience in the matter. Another important is, of course, the reputation, of the person, the experience on the different cases. Also, the experience could be sometimes even experience on the geographical area where your project is involved. Also, it's a good component. Language, it's important, because that will make it probably sometimes cheaper or easier to communicate. And also availability, is getting very hard now in these days to choose good arbitrators, because it's so many arbitrations going on in the region that sometimes it's very hard to find someone's quite available, or also who they don't have any conflict of interest. Diversity is also an important.
I was going to exactly ask that now, because we've been, in the community trying to increase diversity in the pool of arbitrators, and in our view, increasing the pool of arbitrator will avoid overburdened arbitrators, will avoid repeat players. So it will increase the speed of the arbitration, the neutrality, and I think personally that will also increase the quality by bringing to the mix different ideas, different backgrounds, right? Like in any business, you increase competition, usually you're serving the user well. So it shouldn't be very different in arbitration. Now, when you are thinking of diversity, what would you normally consider? Would you consider social background, race, age, gender, and everything, all of the above, and why? What is your view? Because I told you my view as a practitioner and as a member of the arbitration community, and why I think that's important. But as a user, right, of course, you have also different concerns. You want someone that you already know that has a track record. And so how do you balance that? And
good question. I think that we definitely need to have more women as arbitrators, more and more. I think it's important. We have currently a case who is the tribunal is formed by all women. So we feel that it's going to be a good distinction, to have currently an investment treaty arbitration composed by only women as in the tribunal. I think also women are very deep in the way of they analyze subjects and the cases. So in most of my cases, and remembering in Colombia, for example, I have a tribunal that was composed by 2 women and 1 man, and also in Chile. So I've been dealing more with tribunal composed with women. So I think I will encourage more to have more women participation on the arbitration than to be in the old days to be just kind of a male group of people who were considered kind of the experts. So I think definitely gender is important. Background also it's important. No, I think that we have to get more open to the possibility of bringing more social background to the list of arbitrators. No, and also the responsibility to train more people from a broader countries, within the region. Normally, if you go and access this list of arbitrators, are the usual suspects, particularly when you're dealing with big cases. No, I think just enforcing and training and opening the opportunities to practitioners from different social backgrounds would be a great addition to the overall to the arbitrations in the region. Erika.
And Marco, usually before you get to select arbitrators in a case, you as in-house counsel have to decide on outside counsel. So what are the main attributes that you look for in outside counsel when you have an arbitration?
First of all, to have a strong experience on arbitration. I think that I have been lucky to have the big support of the company to choose for really the experts on the field. So basically, what I normally do is go there and make sure that the lawyers that we are looking to represent us are knowledgeable in arbitration procedures, that they have experience dealing with arbitration cases. So that's the most important one, Cristina. Second, of course, to have a specialization in the subject. Sometimes, it's important. Of course, the personal relationship, it's important. I personally, in my case, I have more than 20 years working in the region. So I have been able to develop a good sets of relationships with different law firms in the region. So personal relationship is important. How they manage and control the client expectations is important. Now the interaction with the client and the flexibility of listening to you and your concerns and translate them to the case, how they are helping you. Sometimes proficiency in languages is important. Definitely, dealing in the region. In my case, where I headed Latin America, I can communicate with local lawyers. So normally, of course, I will choose for lawyers who speak the language and who are familiar with a geographical area. I'm not a big fan of looking at publication rankings. So I go more for academic publications of their lawyers or even for recommendations from my colleagues or my peers. And normally we go for the best.
Marco, you said several good things about arbitration and a few not so great things about arbitration. Now, if you had to just pick, your three top, what in your view are the greatest advantages of international arbitration?
Well, definitely arbitration has to be put in as public policy, to have the arbitration as dispute resolution mechanism has to be kind of matter of public policy, because that will also help a lot with companies looking at investment in the region. So arbitration definitely it's a plus. What I see there that is a big difference is, of course, the well-developed set of institutional rules within the region. Also, the possibility of an easy enforcement, particularly, well, if not easy enforcement, at least to give you the possibility to enforce in other jurisdiction as well. So arbitration is good. And broad of capable arbitrators. No, you can choose your arbitrators. You can have good people. I'm not saying good people, good experts handling your cases. Decided in your case. The neutrality of the arbitrators is important in compares with sometimes court litigation that you always are concerned about certain links to the home courts, to the government. The flexibility also is very important. No, the possibility to get involved in how the procedures will work. I think that's fantastic. Something that you definitely cannot do in local litigation. No, confidentiality is also important, as I mentioned to you. I think you don't have the pressure of being monitored or being look at your competitors are looking at your cases. So I think it's also a nice component as well. No, and the drawbacks could be that they are expensive. Could be very expensive. Although, as I mentioned to you, sometimes in litigation you cannot oversee the timing of the process. So you maybe ended being more expensive, but not normally arbitrations are expensive. You have to, of course, cover arbitrators' expenses plus, arbitration's institutions fees. And it's also sometimes there's a limit of document production. No, in the case of discovery, is not apply. So you have that drawback.
I like though that you named several advantages and one big drawback and one potential drawback. I'll go with that. I'll take that.
No, I'm a big fan of arbitrations. To be honest, you feel I think as a cross-border international lawyer that I consider myself trying to promote businesses abroad, I think to have the possibility of having an arbitration as a dispute mechanism, it's a fantastic. No, I think we feel, and I personally feel more in control of the process than just going to local courts or local litigation. No.
Marco, when you mentioned the drawbacks, you mentioned the cost, and I wanted to ask you about attorneys' fees. Regarding the rules applicable to attorneys' fees, what do you prefer? The English rule, in which the losing party can recover the losing party, has to pay for the winning party's fees, and so the winning party recovers not only the award but actually recovers the fees that they spent in attorneys and maybe experts and what they spent in the proceedings, or the American rule, in which each party just bears their own costs?
Absolutely, I support the English rule. So I'm against baseless litigation, baseless arbitration. I personally try to advise senior management or the management not to go to arbitration when we don't have a good case. You started to settle before. So I'm very serious when we go and submit or ask for or go for litigation or arbitration. So absolutely and definitely the English rule, Cristina. I don't want to sue or go to arbitration just because, I have to have a meaning for doing that.
Marco, and on the cost subject, one of our sponsors is a funder, and third-party funding is becoming more and more common in international disputes. I know that Quanta funds its own disputes, but if you needed funding, what would be your major concern? Or
I don't have experience in that, as I mentioned to you, because in Quanta, in my previous life, in another also as a general counsel in a previous company, we normally we support our with our arbitration processes. But I think in some cases it's important to have them, because particularly in very complex arbitration who can take a lot of time, who you are subject to the the illegal or the unilateral action of sometimes of the government in canceling your main project or your only project of your company, put you in a very difficult financial constraint, and you have to defend yourself. So I think the possibility of having somebody who can fund your arbitration process, it's fantastic, Erika. It's a great tool. My concern is probably losing or giving up some control. I'm really a hands-on person. I like to be involved. I like to be help to make some decisions. So I think the challenge would be having a funding. My case is just to giving up some control, but definitely I think it's a tool that you must have, or is good to have in arbitration cases, particularly doing cross-border or international arbitrations.
Yeah, that's a very good message for the funders, because it's coming from a company that actually does not need funding but recognizes the benefits of having the possibility of, having that available. But at the same time, I understand it's just not a matter of economics, but I think the message here would be it's a matter of cooperation, right? It's sometimes allowing the company which knows its case better than anyone else to continue sitting on the driver's seat, which of course, when a funder comes, then you have, to find that balance and find a way to work together. Very good.
Absolutely. Yeah.
Well, Marco, I think our discussion is coming to an end because of time, but there was something that we wanted to ask you at the end is if you could change one thing, one aspect of international arbitration, what would you change?
Not costs, something else.
I think I probably could say speed, although they can be very, very fast, but I have both. I think to have more, to be, could be shorter, particularly with local arbitrations, international, I think that you have a lot of involvement in what to say on that. And I know that Erika say, but I think raising cost is also an issue, if we can keep kind of the cost in a certain way, so you will have more access to investor companies who are dealing in commercial transactions. Sometimes when you are negotiating a dispute resolution mechanism, and if it's a small contract, you are always concerned about going to an arbitration process because it's going to be costly. But if you can keep cost, in a certain way, I think that would be great. But one thing that I've been seeing more and more is the raising costs on arbitration procedures, no? But as I mentioned, I'm a big fan of arbitration.
Marco, thank you. Our discussion got to an end, but thank you very much, Marco and Cristina. I enjoyed very much speaking with both of you today, and thank you, Lauro and the Arbitration Channel for making this happening. Marco, I'm sure your experience today and what you shared was helpful not only to other in-house counsels that might be already using arbitration or considering to use arbitration to resolve their disputes, but frankly to the arbitration community in general. I think that as practitioners and arbitrators, it's very important for us to listen to the users, and I think nobody better than someone like you who understands what your company needs to tell us, what you see that is right and wrong, and what's working, what's not working, and where we can improve. So I think your last point is very well taken, and we will. I think there are frankly many things that we can do to expedite arbitrations, be it for institutions to be perhaps more proactive during the constitutional tribunals, make perhaps deadlines shorter, challenges that are not well grounded be very be rejected right away, challenge to arbitrators or even to for us as counsel as well, right? Procedures are flexible, but I think extensions of deadlines sometimes can be abused, and tribunals should not be afraid of enforcing their orders and dismissing extemporaneous requests. So I think there are many things, even imposing costs when one party appears to be using guerrilla tactics to prolong the arbitration. I think that we could go on here for a long time. So but I will end here. Thank you very much.
Well, no, thank you so much for the invitation, and I think it was a pleasure for me to be also to share this forum with Cristina, who is a good friend and has helped us a lot, and as well with you, Erika, who has been a tremendous supporter for the company. And I'm very happy also to participate in Arbitration Channel in Brazil because I'm a big fan of Brazil. Eu no falo português, pero I'm trying to learn. So I'm very happy with the opportunity to share my experiences with you both, and also for the Arbitration Channel as well in Brazil.
Oh, thank you, Erika and Lauro, for the invitation, and thank you, Marco. It's been great hearing your insights. Sometimes it's good after a lot of day-to-day work on an arbitration to take a step back and kind of think, about what we're doing every day. And thank you so much for your insight.
Thank you, Christina. Thank you.